Keyspan Gas East Corporation versus Munich Reinsurance America.
Thank you.
May it please the court, Robert Long representing Keyspan. I'd like to reserve 1 minute for rebuttal,
Yes,
if
counsel.
I could. This appeal presents two issues. First, whether this court should approve the availability approach to pro rata allocation that has been applied in New York for more than 20 years. And second, whether Century's policies contain an anti-stacking provision that is inconsistent with pro rata allocation.
Can I start you with the second question?
Certainly.
That argument was made in a prior summary judgment motion involving other defendants, correct?
That's correct.
How could we possibly, and it wasn't appealed,
That's correct.
and it still could be subject to appeal from a final judgment, right?
That's correct.
Which this is not. How could we possibly address that issue without those other defendants being heard?
Well, the appellate division said in its opinion that these policies do not contain anti-stacking provisions of the kind that were present in Viking Pump. So we think the appellate division injected the issue into the case by putting it into its opinion.
But if we disagree with that, or I mean, can't we address the first question without addressing the second question?
Yeah, oh yes, okay. I think you can address the first question without addressing the second question. I think, to be clear, if you were to address the second question and agree with us, then it would be all sums allocation and the question of how you do availability under pro rata. You wouldn't even have to reach.
Let's assume, just for now, that we're dealing with pro rata. That's
all right. Well, okay. I'm sorry to hear you say that, of course, Your Honor, but of course I will assume that.
For the sake of argument, we could talk about all sums if you want, but
I understand.
But how is the unavailability exception consistent with what we have said about pro rata and about how we decide these issues based on the policy language, given our decisions in Con Ed and Viking Pump?
So I think in Con Ed, this court said that pro rata is consistent with the policy language, and that in Viking Pump, the court went further and I think effectively said pro rata is not required during the policy period language if there's other policy language, such as an anti-stacking provision that points in a different direction. So we think...
How is the policy language here different from Con Ed?
So three of the policies, the earliest three policies, require only that an accident happen during the policy period. So they don't require any damages during the policy period. That's at A359 and A361 of the appendix. Then, some of the other policies have somewhat different wording. They require an occurrence, and they require damages during an occurrence, but they say an occurrence can be a continuous or repeated exposure to conditions, and that could begin before and continue after a policy period. That's actually just the situation we have here.
That, you'll correct me if I'm wrong, doesn't that say that results in injury in the policy period? So aren't you still stuck with that language about the policy period?
It must result in damage during the policy period. But then most of these policies have language that says all damages arising out of exposure to the same general conditions shall be treated as one occurrence. And it's different from the language that you looked at in Con Ed, which said all damages arising out of exposure to the same general conditions during the policy period shall be treated as one occurrence. So when you add that all up, plus, now we say there is an anti-stacking provision. I think going back to your question, I think you could look at that just a little bit to see whether there's ambiguity.
If we look at that, then don't we come back to Viking Pump, which said that unless they expressly contemplate, those provisions expressly contemplate successive policies, then we only apply them to concurrent policies?
Well, I mean, what I would say specifically about this provision that we think is an anti-stacking policy, it says if any other century policy covers the same loss, then you only get one limit. So we think at a minimum, we think actually that's any policy is unambiguous, but at a minimum, that's another source of ambiguity. All we're trying to do here is get the court to the point where it's...
Viking Pump said ambiguity doesn't do it. It has to be an express provision.
Well, I mean, of course, you are by far the expert on this, but as I read Viking Pump, it did not say we have clear policy language that's in conflict. On the one hand, we have a during the policy period provision that limits damage to the policy period. On the other hand, we have an anti-stacking provision that clearly recognizes that successive policies can cover the same injury.
That's the point that I'm getting at right there.
But in the court's opinion, they didn't say these provisions are in conflict. They said during the policy period language, yes, it's consistent with pro rata, but it's also consistent with all sums of other language points.
So it seems like your argument keeps coming back to the all sums versus the pro rata. So does the application or the even possibility of application of the unavailability exception depend on our finding that this is all sums?
No. I mean, what we're asking the court to do under this pro rata argument, the first question presented, is not to go all the way to all sums, but simply to say, as you did say in Con Ed, the all sums language by itself is not enough to support all sums allocation. The during the policy period language suggests and is consistent with spreading the liability over triggered policies, but this language does not require limiting the policies to damage that happens during the policy. If I could give a very simple example.
Well, let me stop you for a second, because your time's going to run out, and I'm not going to be able to ask you a question at the rate we're going here. So, respectfully, but we all suffer from that. But in the appellate division decision, I think it was Judge Gish wrote the decision. She made reference to, it talked about availability. And she said availability is, I don't need to tell you guys, comes in two forms. It either comes, or unavailability, either comes as a result of legislative action or market forces. We're not talking about legislative action on unavailability. We're talking about market forces unavailability. We all agree on that. Is that correct?
Yes.
Okay. So if we agree on that, doesn't market force unavailability, in essence, and she uses the phrase, amount to free insurance for the policyholder?
No,
And
I mean, no.
Tell me, okay, tell me why.
Well, because again, this comes back to, we think the court can and should find ambiguity in these policies.
The reason I ask the question is I recognize the value of the policy to you, but why isn't it free insurance? It's coverage for a period that wasn't paid for, where there was not legislative action saying that there is no insurance available to you. So you're going as a standalone. You're going as a self-insured person.
Let me answer with this simple example. Suppose someone suffers bodily injury during the policy period, but suppose after the policy period ends, there's some further physical deterioration, such as scoliosis. I don't really think it's been seriously contested over the years that the policy would pick up that damage,
we
even
go
though
back to the occurrences during the policy period is what you would go, but the policy period would still be applicable.
Yes, but I think that's very important, Your Honor. We've just established that this policy language can and does.
The problem with long-tail claims is across the board is that you can't establish the occurrences. That's why you have this problem. Otherwise, we wouldn't be here. If this was your normal automobile accident, we'd have a date of the accident, we'd be done with it. It's a long-tail claim. It's an environmental claim. You can't. It's not you, but I mean, the carrier can't identify the date of the occurrence because they happen over a half a century. It's a gradual occurrence that happens that way. It's impossible to identify. So then the question becomes, you either have coverage during the whole period or you don't. And where you don't have coverage, you don't get paid. And so tell me why this isn't free insurance in that scenario.
Well, again, these policies, and this court's approach is very specific to the policies. These policies say that all damages arising out of exposure to the same general conditions are deemed to be one occurrence. And they do not say, as some others do, all damages during the policy period. So I think we can look to policy language here to say...
But don't they say damages arising from an injury that occurs during that policy period, from an occurrence that occurs during the policy period?
It says, and there may be slight variations.
It's not an amorphous damage, right?
It says damages arising out of exposure to the same general conditions or a continuous or repeated exposure to conditions. And a big part of our submission is, the insurers knew about this problem and they tried to write a formula to allocate liability. They couldn't agree on anything. They deliberately left it out. So what we're debating here today is whether language that was really not written to cover this situation of the long tail indivisible damage not only does answer this question, but answers it unambiguously and in a way that is devastating. We give an example of asbestos plaintiffs.
Well, you would agree that there are some policy considerations both ways. Obviously, you feel that your policy considerations outweigh the other side's, but it's not completely one-sided.
Well, very respectfully, we feel that once you get to the point of saying, okay, the policy language does not answer this unambiguously, the public policy arguments very strongly favor sticking with this availability approach. The example of, in terms of reasonable expectations of policyholders, if your asbestos-caused disease manifests 30 years later than somebody else's, nobody would expect that your coverage gets cut by 75%.
Yes, but it's for an injury or occurrence in the policy period, if that's what the policy says, which these say. Aren't you still stuck with that?
Well, we're stuck with it to the extent that there must be an accident or occurrence during the policy period. That's common ground. For most of these policies, not all, but most, there must be damage during the policy period. What we're saying is ambiguous is the final step saying, and only damage during the policy period, nothing outside. I think we just gave a simple example that people accepted that, look, if the scoliosis continues outside the policy period. In the environmental world, a simple example, these are so complicated. Suppose just one spill just happens during 1 year. That's clearly an accident, an occurrence. There's damage. The policy is triggered. Suppose then it takes 10 years to clean up that spill because you have to get the regulatory agencies involved. You have to get a plan. It has to be signed off on. Public notice and comment takes time to do it. Is it really consistent with the reasonable expectations of policyholders and with 2,000 sites, as we understand it, in New York that still need to be cleaned up? Is it sensible to say that since 10 years went by, the insurer is going to cover 1/10 of that, and 9/10 are now, could be for the taxpayer if there's no...
Thank you, counsel. You have rebuttal time. Thank you.
Good afternoon, Your Honors. John Hacker for Century. As we've already discussed in not just Con Ed, but Viking, Global, Roman Catholic Diocese, and many other decisions, this court has held time and again that insurance policies, like other private contracts, must be interpreted according to their plain language.
How is this different from an auto insurance policy that covers an accident and the injuries, the damages go on beyond the policy period? How is this different from that?
So 2 points I would make. It always is going to turn on the language, so I can't say categorically whether it's different from an auto damage policy. So that's the first most important point. Second, when you can attribute the damage, if the damage all occurs at that accident, the fact that it goes on and that there's treatment that happens later is a remedy for the damage, but the damage occurred in that policy year. So that would be another, at least depends on the facts of the case. But then the third is what is really relevant, I guess, turning back to my first point, is focusing on the language in this case. And a couple of times, my friend Mr. Long quoted the relevant language, but then left off, every time, left off the most important provision, and that is that the coverage provision covers definition of occurrence. It's the same words that this court construed in Con Ed. The definition of occurrence is an accident or, quote, continuous or repeated exposure to conditions, then he would stop, to conditions which result during the policy period in damages. So it's not just an occurrence or an accident. The damages have to occur during the policy period. And this court in Con Ed, then reaffirmed in Roman Catholic Diocese, then reaffirmed in Viking Pump, said that that establishes a rule, that language establishes a rule that the policy only covers damages that occur during the policy period. It doesn't cover damages that occur outside the policy period. And definitely, Con Ed and no other decision with which I'm familiar says that the language means this policy might provide coverage depending on the reason that there's no other coverage available.
That's not really the way I understand their argument, though. The way I understand their argument, I'm not saying I agree with it, but the way I understand it is that there's an occurrence during a policy period. Then there's a period where insurance is unavailable. They can't get you, they can't get somebody else. That coverage that they had when the polluting occasion occurred carries over across the period when it's unavailable, not through fault of their own, but because the market isn't either providing insurance that we're assuming we're striking out the legislative action.
I agree that that's their argument, but the problem is it just doesn't.
How is that different from I hurt myself in an automobile accident and my policy expires a year afterwards, but yet you're still responsible for my medical costs?
Well, if the damage, again, it would depend on the facts of the facts of the case and the policy, but if the damage occurred in that accident.
So the nature of a long-tail claim, though, is like you have said, you've articulated it, it's a gradual and continuous, usually, exposure to polluting agents.
That's correct.
So inevitably, there's going to be an occurrence during a policy period.
That's the assumption. When you have long-tail exposure, you can't figure out when the occurrences are, what they are, and what the damage is. So it's a given that it did occur during a policy period. So if it occurs during any policy period, why doesn't it carry over then under their argument? Well, because Con Ed says that's the whole point of when you have an injury and you can't identify how much damage occurred when, what the actual incident was in any given policy year, what you do is you assume, absent contrary evidence, you can have fact-based allocation, but you assume that the damage occurred evenly throughout that period, and you attribute each year's worth of damage to each policy period,
well,
so long as the policies say.
I do understand that, but it doesn't answer my question, which is the occurrence problem. If it ever happened during your policy period, the theory is, does it carry over to the uncovered period?
And the answer is it doesn't. I think because Con Ed says it doesn't, but I also think Viking Pump says it doesn't. By negative inference, Viking Pump says, here's a set of policies where it does carry over because the policies explicitly said that they do, right? There was a continuing coverage provision that answered that question. In this policy, there is a continuing coverage provision for the advertising injury. Explicitly says for that particular type of injury, it carries over.
The real answer is these policies are not like automobile policies.
In that respect, again, that's why I didn't, I don't want to assume away all automobile policies, but in that respect.
Bottom line, though, is they're not the same policies. The language is different, and the language is key.
The language for sure is key. And there's nothing in here, unlike in Viking Pump, that was the express holding of the case, and Your Honor had it exactly right. Viking Pump reaffirms Con Ed and says that when you've got.
So let me ask a slightly different question here. So under your approach, how are they incentivized to ensure, which of course society, being concerned with environmental contamination, wants these kinds of risks to end up being paid for in the private market through the insurance market? How does your approach incentivize them to purchase something that they cannot purchase? Because isn't that what the unavailability doctrine is in part trying to deal with? The fact that there's nothing to incentivize them on because there's no insurance that they can purchase.
Unavailability in the New Jersey Owens, Illinois case was basically invented because Owens, Illinois adopted a completely different reason for pro rata. It said, unlike this court in Con Ed, Owens, Illinois says the policy language doesn't tell us anything meaningful, so we have to literally make up a rule. We're going to make up pro rata because that will incentivize, as Your Honor says, the purchase of insurance ex ante, but that incentive would only apply so long as it can be purchased. That's just not what we have here, given Con Ed's construction of the contract language, which says it only covers damage during the policy period, which means it doesn't cover damage outside the policy period. And so it's categorically irrelevant, as I say, what the reason the insured doesn't have coverage for is. For example, the first part of the policy of the coverage of the of the damage period here, for decades, insurance was illegal in New York. You couldn't buy insurance if you wanted to, and insurers couldn't sell it. And yet their theory would shift the liability to the insurers for several decades when we couldn't sell it if we wanted and they couldn't buy it if they wanted.
And your approach shifts it to them?
I'm sorry?
And your approach shifts it to them?
It doesn't shift.
And it doesn't go to somebody else, right?
No, right. They bear the liability for that period when they were operating and dumping tar on the ground, two things that are undisputed.
So as a policy matter, your argument is, well, since they're the polluter,
but it's
shift
not,
it to them.
it's not from an equitable
I know
sense.
your argument is on the language of the policies, absolutely. It's a different question I'm asking.
100%, but not just as an equitable matter. It's also the point that when they were operating and polluting and they didn't have insurance, the one thing they knew is they didn't have insurance. There was never going to be coverage for what they did during their operations. It doesn't mean they're bad people. They were operating without insurance.
So
no reasonable insured ever could say,
So then they
maybe
should
someday
take
I'll
the
have
risk of
insurance.
that and the cost.
I'm sorry?
They should assume then the risk and cost of that.
By definition, they were assuming the risk. and
So is there a
cost.
reason to think about unavailability differently for the period a long time ago when no one contemplated this sort of a risk, and unavailability after insurance had been available, then perhaps became unavailable? Is there a reason to think about those differently?
I ultimately don't think so. I think the answer is no, because when insurance is not, when insured, a company is operating without insurance, there's only three reasons for that, right? There's only three possible explanations for operating without insurance. One is the company doesn't want it, has assumed the risk itself, doesn't think the premiums are worth it. That's one explanation. Another one is the insurers decided not to provide it, that the risk was not something they wanted to take on. And the third is that the state said, I don't care what either of you wants to do, we're not going to let you take on that risk. Those are the only three possible explanations, and all of them are equally valid from the perspective
Well, or
of
that no one has
the law.
contemplated that there's a need for a particular type of insurance. So, for example, insurance for internet-related identity theft wouldn't have been contemplated 100 years ago.
Right, so it
So
wasn't.
that's a fourth reason.
Well, I think it's basically the same as the point
It's
is
a market-
neither
it's a
party
market type
thought
reason.
it was worth, that there was neither party perceived a risk that they wanted to
No, I think
take
Judge
on.
Wilson, unless I'm misunderstanding him, I think what he's asking you about is there's a difference between no one anticipating and contemplating that this was a risk that perhaps merited insurance versus there's a risk and the market, the insurers say, we don't want to take on that risk, we're pulling out of this business.
There may be a descriptive difference, but I think analytically it's not, because on the first hand, whether the operating company understood the full range of risks, what it knew is it was taking on the risks. And that's what happens if you don't have
They
insurance.
bargained for it.
They chose, they didn't have insurance, they decided to operate without it. I mean, they knew that there weren't going to be coverage no matter what happened. That's just, it has to be correct. In the latter period, assuming the insurance industry or insurers decided not to provide, you just have the flip side of the transaction. The insurer said, this is a risk we don't want to bear. It doesn't make sense for us to take it on.
Your time's up, but if I may.
Yes.
You suggest somewhere, I think, that whatever we rule in this case, we don't have to worry about what's going to happen in the asbestos cases, which your adversary brings up as, a scare.
Yes.
And how do we do that? How do we defer that and not reach that? And why isn't the rule going to be the same?
I think the rule is going to be the same, and we don't mean to suggest otherwise. Our point simply is, given the language, given the contract bargain that's struck here, the same rule does obtain. But I think it underscores the point that their argument for an equitable exception, they're just seeking a made-up rule for reasons that they think are good and sound reasons, are focused on the asbestos problem. If this court is going to depart from the tradition of enforcing the language and promoting the stability that comes along with that, if this court is going to come up with a new and special rule, the time and place to do that would be in a case that presents and raises the asbestos problems, where there's a record that shows what they assert, which is there would be problems, greater problems that we, as far as I know, we have not seen in Massachusetts, in South Carolina, and in the other states that have adopted, that have rejected the unavailability exception under pro rata allocation. I don't know that there has been some massively exacerbated problem with asbestos, like they say. But if that's the reason to do this, to depart from the tradition of enforcing contract language, the court ought to do it in a case with a record on those kind of facts. Thank you.
Thank you, counsel.
If there's no ambiguity in this policy language, then it's got to be the same answer for asbestos and toxic torch that it is for environmental cases. We agree the policies require an accident during the policy period, or some of them an occurrence during the policy period. Many of them, but not all, do require damages during the policy period. But we think there is ambiguity on this final step of whether they cover only damages during the policy period. We think, in fact, sometimes they clearly cover damages that go beyond the policy period. The insurers knew about this problem. They thought about writing language. They deliberately chose not to put a pro rata allocation formula into these policies. The during the policy period language is they're trying to make it do just too much work here. And in these particular policies, they defined an occurrence as a continuing exposure to the same conditions. They didn't, and they said it shall be counted as one occurrence, and they did not limit it to one policy period. I submit there's ambiguity here, and when you look at broader public policy concerns, there are overwhelming reasons to continue with the availability approach the New York courts have applied for more than 2 decades.
Thank you, counsel.